With over 1 lakh home buyers still stuck across India and companies like JP Infra, Amrapali, Unitech, Today Homes, well, the list is long. The outcome of JP Infra case will perhaps become a benchmark for several other real estate companies which could be taken to NCLT by lenders. But the broader issue, and I'm going to go to Mr. Chitale, who's with us from Mumbai studio, what is the legal impact of this case on other similar NCLT cases, sir? And how does Supreme Court now balance what is in IBC, what is outside of IBC, what are interests of home buyers and what are lenders' interests, sir?
Sure. I think we need to divide this into two parts from a home buyer's perspective. One of the cases which are already in the NCLT and the others are ones which will come under the reform which has happened under RERA. So for cases which are under NCLT, unfortunately, I must say that because this is a case which is being addressed by the Supreme Court under Article 142 of the Constitution, this may or may not necessarily become a precedent to be applied by the NCLT and NCLAT in other cases. Because this is a remedy available to the Supreme Court and not to the bodies of adjudication which are created by the statute. So unless the legal changes follow to accommodate the interests of home buyers, either at least on par with those of the other lenders, I think there is a challenge of what is the precedent value of this particular case. Going forward, there will clearly be a need in other cases which do not necessarily fall, are taken up by the Supreme Court to see how best to address the issue of home buyers. The committee has recommended that the amendment should happen to the law. That amendment does not necessarily take full care of the home buyers, but that is inevitable because they are one of these stakeholders, and therefore, in some shape or form, the question is, how does one allocate the pain to the people who are going to suffer it? And there can be a clear social case of having lesser pain to the home buyers, but to say that it will be completely painless to the home buyers, and therefore the pain which is allocable to the home buyers will get allocated to everyone else, may or may not necessarily be in place.
Well, Mr. Chitale, the only quibble here, or at least I have this quibble, though nobody else might have it, that the pain of the home buyer is a personal pain. It is not the same as the banker's pain. So these are very two different things that we are talking about. And but anyhow, you've made a very important point. Abhishek Dubey, would you agree with it? Are you okay with the highest bidder now, let's say on July 4th hearing, if the Supreme Court says rebids come and goes ahead and says at whatever value the highest bidder now gets into the system, gets the company, is that okay with you?
Yeah, that is fine because see, there is no other option. There has to be the highest bidder selected by the COC that will, that should take over the company. There is no other option. And secondly, to respond to Alok, JAL is already in the second list of, companies which RBI has released. So therefore, a bankrupt cannot bail out an insolvent, right? So JAL cannot take it over.
JAL cannot take it over. It is in the second list. That's number one. Number two, well, the irresolution, IRP also has gone to court with the 858 acres of fraud which has got committed. So there is already proof of fraud which has got committed. Chitra?
Yes, Manisha. I would like to say something. All the bidders who are buying this company, why? Because there is land, which we all know doesn't depreciate. It appreciates. Why do you think these companies are coming? Because they know once they acquire, they can unlock the value, which right now, since real estate is a laggard sector, why is it a laggard sector? Because of these builders and their greed. They just wanted to siphon off money. Tell me a company like JIL, which had triple financing, right? They had floated a IPO.
Okay. That is also well established.
All the money,
it was a
everything
free for all
was
market,
there.
Chitra.
I have given money for a flat. So if these companies are coming in, they are smart people. They know the kind of value unlocking this real estate company will have.
It's a complicated case, Alok. At best, any final word before we wrap out?
What I would like to say is that for the home buyers, they should think very hard. They should sit down with their own counsels and advisors, prepare a game plan, know what they are seeking. merely asking for everything is a zero game. So they should have a clear head in their mind.
Of what
this
they
is
are
the value.
seeking. I think I'm going to, I'll have to wrap out here, gentlemen. Thank you very much, Chitra Sharma. Thank you very much for joining me. I think the home buyers are just seeking their homes. At the end of it, it's been 10 years. Their homes haven't come to them. And they're saying, okay, if we're willing to take some sort of haircut, I think everyone's kind of got used to the idea. They're not going to get the entire penalty. But it's a question of, what are their rights? I mean, because of IBC, that entire Pandora's box also got opened up. And now I think with Supreme Court rests the very heavy burden of ensuring that there are clear-cut rules to ensure that stuck home buyers get their homes over and above everything else. I know that the panelists here and the law of the land perhaps does not think so, but I think this is an emotional issue. And like I'm going to conclude, and with my take, that the home buyer's pain is extremely personal. The banks is not. Thank you so much for watching me.